Commonwealth of Massachusetts. Court is now open. You may be seated.
Good morning, Ms. Bannon. Mr. Cockfield?
Thank you, Your Honor. Gavin Cockfield for the plaintiff and appellant Christian Haufler. This is an action involving two neighbors and some property located in Marshfield, Massachusetts. Before you are two counts of a multi-count complaint. Judge Healy heard this case in Superior Court. The first count involves an action seeking to clear a cloud on title involving a deed that was recorded concerning a small parcel of land. The parcel that was the subject of this action is vital to my client's right to build on his property. The property at this point is undeveloped land, and he wishes to build a single-family home there. The facts which gave rise to it are that a deed for this parcel was delivered to an attorney with a draft escrow agreement for recording at a later point in time. The reason that the land was going to be conveyed to his abutter was that the abutter wished to have this parcel of land in order to even out his lot lines. At the time that this...
In order to what?
Excuse me?
Could you just say the last sentence again? I didn't hear you.
Even out his property line.
Even out, okay.
The reason the land was going to be deeded to his abutter was so that he could even out his lot lines. At the time, but on this small parcel of land was a cottage which would allow my client, under the zoning laws, to take down this cottage and build a single-family home on the remainder of his parcel of land. The judge of the Superior Court found that when the attorney for the defendant, Zotos, sent a draft escrow agreement to my client, Mr. Haufler, who is an attorney, my client signed the agreement, executed a deed, and returned it to Attorney Graham. The trial judge found critically that when Attorney Graham sent this draft document to my client, that was an offer made on behalf of his client, the Zotoses. There are two issues which we seek to, which we claim are error made by the trial judge. One is that Attorney Graham did not have authority to make an offer on behalf of his client, and two...
Wasn't that though, a question that would be up to the judge, a question of credibility, and it would be up to the judge to make that determination, and if there's evidence to support the finding, then it's...
It would if the judge made his finding based upon actual authority. But if you read the way the judge phrased his finding of authority, he said that Attorney Graham, as the Zotos' attorney, had the authority to make this offer. I read that sentence to be the attorney had implied authority, not that he had actual authority. There was quite contradictory evidence in the record, strong evidence from the defendants that they never, that Mr. Zotos never spoke with with his attorney. He never discussed this triangular parcel. He never discussed the easement. That he didn't give him authority to enter into any agreements. The judge's finding, I would suggest, is indicative that he felt the attorney had implied authority as an attorney for his clients to make this offer.
Well, how could this, I mean, I'm not sure, I haven't read all the testimony, but you said the testimony was contradictory. I take it that Mr. Zotos also said other things, in fact testified that he did give Attorney Graham authority or something, didn't he?
Yes, he did.
Because how could it be possible that Mr. Zotos never talked to the attorney? Did the attorney just make all this up out of whole cloth and send a draft agreement on to Mr. Haufler? I mean, of course not.
The evidence suggested that it was Mr. Zotos' wife who was having the conversations with the attorney and not Mr. Zotos.
Yeah, even in your brief, you say Mr. Zotos did testify that he gave Attorney Graham, quote, full authority, unquote, to negotiate on his behalf.
Correct. And I am pressing my argument not on the actual authority. I would concede that on the basis of if the judge found there was actual authority, that given the standard of review on an appeal, that the judge could have concluded that. My argument is that if you read the judge's finding, he is saying that the attorney had implied authority. He rejected impliedly the testimony of Mr. Zotos. He found elsewhere in the record that Mr. Zotos was not testifying credibly. And that I would suggest that if you read his finding, you could clearly see that he was saying that the attorney had implied authority, and it's quite clear in the law that an attorney, when it comes to a real estate transaction, does not have implied authority to negotiate substantial modifications of the transaction, which is what this escrow agreement would have been. He was retained to handle a purchase and sale agreement. The purchase and sale agreement provided that another party, Mr. French, was going to sell the land to the Zotoses, and that Mr. French would sell this small triangular parcel of land. It did not, Mr. Haufler was not a party to that agreement, and the escrow represented a significant departure for what he was retained to do. But moving aside from the authority issue, and more important is, was it an offer? The judge's finding was, when Attorney Graham sent this draft document to Mr. Haufler, that was an offer. And then when Mr. Haufler signed it and returned it with the deed, that was an acceptance. I would agree that if he had authority and if there was an offer, then Mr. Haufler's actions would be an acceptance. That's clear. The question is, was the sending of the document an offer? If you look at the document requires that it be signed by both the Zotoses and Mr. Haufler. It provides that it's going to be signed under seal, and it provides that it needs to be that the signatures need to be attested by a notary. I would suggest that it's clear black letter law that an offer is read under the restatement to be what a reasonable person would believe to be, would invite an acceptance. I would suggest that Mr. Haufler would not believe that the mere document itself was an offer.
Well, he wouldn't believe it. Wait a second. He executed a deed. He signed it. He executed a deed, sent it back. He also executed a mortgage on his property and sent along a check for $5,000 subsequently. How could that not... He obviously was acting as if he had accepted the offer.
That's the question, though. Was it an offer? I concede the point that his actions, if there was an offer...
But you said it's an offer if a reasonable person would perceive it as an offer. I assume your client's reasonable. He certainly acted as if he had perceived it as an offer, which he was accepting.
I disagree. In many transactions, Your Honor, it contemplates that an agreement will be formed when a document is signed. The mere signing of one party could never be the acceptance. In almost all transactions where you have a formal transaction where the parties contemplate that they will be bound when they sign a document, if only one party signs that agreement, how could it be binding? I'm sure if the tables were turned, that the Zotoses would be here arguing to you that they did not sign the agreement and therefore they were not bound by it and their attorney didn't have the authority to make an offer. It doesn't matter that Mr. Haufler just signed it. Mr. Haufler's actions in signing the agreement was the offer. He was acknowledging that he was willing to enter into this transaction. That's clear.
And so your argument is because the Zotoses then neglected to sign it for a year that it had expired.
Correct.
But did your client do anything to indicate that he thought it had expired? I mean, he assumed that the Zotos had signed the agreement, I assume. I mean, he didn't withdraw his mortgage. He didn't say, send me my check back, send me a copy of the signed contract back.
No, number one, when he sent it with an instruction that varied from the terms of the offer. He said that I'm assuming that, he said, this deed will only be recorded when my foundation is put in, which never occurred. During that one-year period, there was a letter sent by Attorney Graham which said that there was going to be an extension of the time for recording the deed, but he specifically referenced a different agreement which had been involved with the Zotos' predecessor in title.
So why would he have sent it to your client if it wasn't intended to reference the only agreement your client had with this attorney?
Because there was a prior agreement with the Zotos' predecessor in title, which similarly required the conveyance of the parcel, which had been extended over a period of time, and that agreement had been assigned to the Zotos', unbeknownst to my client. During the course of this year's time, there was conversations back and forth between the parties concerning whether or not and when this deed would be recorded. In fact, my client didn't believe that they could record the deed that he had sent to them because a plan, which is required by statute to accompany the deed, had not yet been prepared. He felt he held all the cards and the deed could never be recorded.
Mr. Cockfield, I think if you can use your time whichever way you want to use your time, but it would be very helpful if you got to the civil rights, which is the second point, correct? You said you had 2 points that you wanted to make.
Yes, I'm moving to that now.
Okay.
Thank you, Your Honor. The next count involved whether or not Mr. Haufler's, whether or not the Zotos has violated the State Civil Rights Act in connection with the Zotos' interference with his right to use, enjoy, and develop his real property. We contend that the trial judge made 2 errors in that regard. First, that he misapplied the Act and how it should be applied to the facts of this case, and 2, that his underlying subsidiary facts don't support his ultimate conclusion. The judge, if you read his decision, found that, or stated that under the State Civil Rights Act, that a physical confrontation is an important element under the Act to find a violation, and that the collective acts of the Zotoses didn't amount to a violation of the Act. We suggest that there's two errors there. One, the judge overly emphasized the requirement for a physical confrontation. The Act actually doesn't require a physical confrontation. This Court has noted twice, without actually reaching the issue, that a physical confrontation is not necessary to find under the Act. And more importantly, the judge discredited or did not give any weight to the acts that were directed by the Zotoses against third parties with the effect or the intent to interfere with Mr. Haufler's use and enjoyment of his property.
And in fact, I take it that it did interfere with the use and enjoyment of their property. The surveyor was thrown off the property.
Exactly. There was repetitive acts that did. There was, number one, we have this long train over in excess of 30 complaints written to the municipal officials challenging the development of my client's property.
Well, surely that can't be a violation of the Civil Rights Act. Complaining to public officials about your client's plan to build on his property? In writing?
I would suggest that doing that in a way that where the judge found that these were largely meritless complaints.
But it's a lawful act, isn't it?
I would suggest that if you do something with the intent of trying to interfere with someone's use of their property, it is not, and it is the collective acts. I mean, the Alassi case and the Bell case, both cases involved situations where in the fact pattern, they were both abutter cases, and in both cases, part of the acts that were found could support a violation of the Act
Mr.
were...
Copfield, that may be helpful as background, but there are, as I understood your brief, there was evidence of what really is physical confrontation, leaving aside whether your legal point, correct? I mean, that was just...
That is exactly the point, Your Honor, that it may be background, but it supports the overall course of conduct where they were seeking to interfere with the use of the property. The simple facts are, if you look at the subsidiary facts found by this judge, there are acts that would clearly support actual physical confrontations. In other words, would a reasonable person have perceived that a physical confrontation would result? 5 witnesses testified that as a result of their confrontation with Mr. Zotos, they felt that a physical confrontation was imminent, that if they didn't back off and leave, something was going to happen, that they were going to be attacked. I would suggest those were actual findings of the court in terms of what these actions were, and then you have the testimony of these witnesses interpreting how they perceived the conduct of Mr. Zotos. Mr. Zotos, look at the testimony. The court found that Mr. Zotos took sawhorses, put them in the only private way that gave access to my client, and left them there. The testimony was that these sawhorses remained in this road for over 2 years, that when Mr. Haufler would come onto the property, he'd get out of his car, he'd go to move these sawhorses. Mr. Zotos would come running out, replace the sawhorse. Mr. Haufler would tell him he objected to them. And then Mr. Zotos would laugh and say, go ahead, call the police. That's a physical confrontation.
What about the evidence of the expert witness who, did Mr. Zotos contest that he ran at this witness with a rake, holding it, like Pleasant Arms, whatever that Pleasant Arms style?
I believe it means he ran at him with the rake. He was running at him with a rake raised, and that the witness testified, who had been hired by Mr. Haufler to assist him in the development potential of his property and in connection with this case, that he felt he left. He said, I drove off because the guy's running at me with a rake.
Did the surveyor have to get a police officer to come onto the property?
The surveyor, after he was
challenged?
ejected from the property, felt that he got a uniformed police officer to come onto the property. When the uniformed police officer is on Mr. Haufler's property, the judge found that Mr. Zotos came out, confronted them, jumped up and down, used epithets, called the police officer a word which I won't repeat in this court, and the police officer decided that the situation was such, it was so bad, that the uniformed police officer and the people should leave until they got a court order allowing them to come onto the property. Those are all clear acts of someone would put a reasonable person in apprehension that there's going to be a physical harm that's going to result if they don't back off and leave. And I would suggest that those subsidiary facts found by the trial judge, and it doesn't matter that they were directed at third parties. The case law is quite clear that the act does not require the physical the threats, intimidation, or coercion be directed at the plaintiff. They require that the threats, intimidation, or coercion interfere with the use, with your protected civil rights, in this case, the right to use or enjoy your property. I would also suggest that if this court was to conclude that and this is what really gave rise to the action, not in itself, but in large part, is the recording of the deed and how the deed was acquired. They went to Attorney Graham. They threatened to sue him. They threatened to report him to the Board of Bar Overseers. I would suggest that that is coercion. If you look at the definition of coercion.
Excuse me. This is their attorney who is refusing to turn over documents.
Correct.
They're upset. Why wouldn't they report that to the Board of Bar Overseers? That's the kind of complaint we get all the time. Attorney refuses to turn over documents to his client, who has every right to have them.
That's the question. Did he have it? Attorney Graham was refusing to turn it over because he didn't believe they did have a right to have it. That's the point.
So Attorney Graham says, I wasn't operating as their attorney.
He wasn't their attorney at that point. They had retained a new counsel. He was only acting as a potential escrow agent at that point. And he felt that the deed should not be recorded, which is why he was refusing to turn it over.
So what is their remedy? Threaten to sue? Threaten to report on the Board of Bar Overseers? Why isn't that their remedy?
They could bring a legal action. But the point is, look at the definition of coercion. They're threatening to report. I mean, an ordinary attorney. If
I think you're my attorney. You've got documents that I believe are mine. You refuse them to turn over. Why isn't my referring that to the Board of Bar Overseers a threatening act? I may choose to file a lawsuit and incur a lot of expense. I may think you're acting unprofessionally and refer it to the Board of Bar Overseers, who's charged with investigating complaints against attorneys.
Well, I would suggest that's the point. You just said it's a threatening act. I think that's the whole point.
But a legally threatening act.
It's coercion if you look at the definition.
I'm going to file a lawsuit against you. That you would suggest that is, even though it would be perfectly legal for me to do it, and I have a dispute with you, that because I threaten to file a lawsuit, that's a threatening act for purposes of the Civil Rights Act?
I would suggest that it's coercion to tell a lawyer that you're going to sue him and report him to the Board of Bar Overseers if he doesn't do something which he feels he's not supposed to be doing.
And would
Mr. Cockfield, I understand that you're responding to Justice Cordy's questions. Do you want to do a follow-up question, Dr.?
Thank you, Your Honor.
Thank you. Mr. Kelly?
Yes, may it please the Court. I'm Attorney Robert Kelly. I represent Tom and Nancy Zotos in this action. I will point out for the Court that I was the attorney who conducted the trial on behalf of my clients. I say that with some emphasis because it is a very fact-dependent and intense factual case. And I noted, and I want to note that I'd like to argue in reverse to my brother. I'd like to discuss the civil rights case first, and then I'll direct my attention to
I must say that the judge's findings are really of fairly outrageous conduct by your client. How could they not be threatening and coercive within the meaning of the Civil Rights Act?
I think that's why I wanted to emphasize how fact-dependent this case is. Please understand that my client was sued. Very, very important. In the case law, Mays v. Bell and Alassi, those cases involved somebody that initiated action, that wanted to prosecute the other side with some kind of an emotional component. I'm going to do whatever I can.
Here, the plaintiff wanted to have his land surveyed. He has a right to have his land surveyed, and your client threatened the surveyor. Isn't that an interference?
First of all, Judge Healy,
isn't that an interference?
Judge Healy did not find
Let me finish my question,
okay.
please. Isn't that an interference with the plaintiff's right to enjoy his land by use of force, threats, or coercion?
Absolutely not, and I urge you to really examine the facts very closely. There was a gentleman by the name of Garvin who testified, and he was qualified as an expert. He wasn't an appraiser. He wasn't a surveyor, but he testified that he took a 60-foot bucket truck onto the property line of my client. Now, this was before this dispute over the surveyor, et cetera, et cetera. He also testified that he took a plane and he surveilled my client's property on numerous occasions. And you know what the purpose of that was? It was to try to drum up some conservation wetland bylaw violations. But it was used in the context of this case. In fact, Attorney Haufler testified that he paid Mr. Garvin over $3,600 for his services as part of this case. So when the issue of the surveyor came up, now, as you know, there's a statute that gives probably, some people might argue, undue protection to surveyors to be able to walk all over other people's property. But my client merely wanted to have this person identify themselves and qualify themselves as a lawful person who has the license to survey, because Garvin made himself out to be a surveyor. He testified that he was on the property line taking photographs of the Zotos' property. Again, I urge you, the facts here are very fact-dependent. You have to look at the context. I go back to one point, and the dissent in the Alassi case really underscored it. After the case is filed, cases are prosecuted zealously by attorneys, and Attorney Cockfield did a heck of a job in this case. I was on my heels the entire time. The point is, cases are, in effect, coercive. They can be intimidating to people that don't understand the system.
But they're not violations of the Civil Rights Act.
Right, but what about the fact that when you're embroiled in the lawsuit and people are making judgments that cannot be compartmentalized, they have to be viewed in the totality of the circumstances. You can't, again, I have the advantage of sitting here and saying, Judge Healy heard all the facts, and he might have said that, and these facts are very nuanced, I'm going to suggest hyped, but if someone's holding a rake, Mr. Zotos is on his own property. He's not on someone else's property, Your Honors. And I think Justice Cordy emphasized the sort of the conflict between what is this is a court case, and this is involving litigants that are now embroiled in a squabble that people are doing, both sides are acting, in my opinion, in a very uncivil manner at times in this case. I had to chastise my clients at times, but again, you have to look at the facts. They were on their heels the entire time. They had Mr. Haufler coming to the property. He had no house there. And again, the underlying dispute, I don't think there is a dispute that Mr. Haufler was trying to use the law, the Section 81L exemption to the subdivision control law, to his advantage, trying to get 2 house lots, very disputable. I would suggest that any person has a First Amendment right to say there's something wrong with this. If a person wants to use a bunkhouse, a garage, and call it a bunkhouse, there's something inherently wrong with this. So if Nancy Zotos lodges, it could be 1 letter and it could be 1,000 letters. I don't think the First Amendment talks about quantity. I think the First Amendment protects legitimate exercises of free speech. And if she wrote 1,000 letters, they were all legitimate. That's what Judge Healy found, and I do not believe.
Mr. Kelly, what is there in the Civil Rights Statute that says that you have to be on somebody else's property?
Well, that
Wait a minute. I mean,
yeah.
If people feel coerced, the fact that you are standing on your own property, is there anything in our law that says that that means that you are protected? I'm not talking about the letter writing, but if a police officer is called to the scene and feels that there's, that they've been threatening acts, is the fact that he's standing on his property, does that make, as a matter of law, does that make a difference?
No, but I think you contextualize all behavior, Your Honor. And when you have somebody that you believe is attempting to trespass upon your property for unlawful means, i.e. a surveyor without the proper licensing to utilize that statute, I think now it kicks in reverse.
Now, was there any evidence that the surveyor had actually entered onto Mr. Zotos' property?
Well, according to the testimony, and again, you have to look closely, the surveyor was there to try to determine lot lines. That was one of the big pictures here.
My question is, was there any evidence that the surveyor had entered Mr. Zotos' property, crossed into his property?
Yes, absolutely. Most surveyors have to go on other people's property to conduct a lawful survey because they're doing lot lines, so they have to go on one side and the other. That's the purpose, in my judgment, of having a statute that essentially says a surveyor has a right to come on your property with proper notice. The problem is the Zotoses were hoodwinked into believing this gentleman Garvin, who was there to take photographs of their property and later bring before the local conservation board in an attempt to get them to bring a charge of them violating the wetland bylaws, which, in fact, is a case that's pending before the Superior Court right now, so their objective was somewhat met.
But was there a surveyor that actually went out to the property?
There was. And again, there's another issue here.
But wait a minute, let me finish. Did the judge find that Mr. Zotos had engaged in some kind of threatening conduct towards that surveyor?
No, he said that he said that it was that I'm sure that Mr. Haufler was distressed by the conduct Now, again, Judge
What did
Healy
the
is
survey-
on my side in this particular issue. He wasn't on my side in many others, but
What-
I don't
what did
see
the-
how he's abused any of his discretion as a fact finder in this particular matter.
Did the surveyor testify?
Yes, the surveyor
And
did
what did the-
testify.
what did the surveyor-
And he did testify that he felt, and again, it's somewhat of a nuanced approach. He's obviously biased. He was paid by the other side. He testified that he attempted to access the Haufler property. Mr. Zotos ran him with a rake, holding it like present arm style. It's up in the air. I was quite concerned for me, so I just drove away. I was quite concerned for me. It wasn't, he didn't say he felt threatened. He didn't file a threats complaint with the local district court or anything like that. These are very nuanced representations of the facts, I would suggest. And because they're nuanced, you have to give Judge Healy a lot of deference for sitting there for the number of days that he did. And quite frankly, I was not happy that the case took so many twists and turns. It should never have done that. But it was in part because the other side, where the plaintiff was an attorney represented by a great law firm, did an excellent job of putting us on our heels the entire time. And I'm saying that because it was the truth. But if that's in and of itself inherently coercive, I mean, it's not illegal, it's not unlawful, but it tends to intimidate, it tends to coerce, then whatever response the Zotoses make, how could that be deemed a violation of someone's civil rights when that particular statute had a legislative history of trying to correct racial injustices that were so rampant in the 70s in the Boston area and in the country at large? You know, as you know, it was rooted in Section 1983.
Excuse me, Mr. Kelly, did Judge Healy make actual findings about the surveyor?
I believe that, and I'd have to go back and look, but his findings were detailed in some respects, but they were, there's no way you could really detail them without really writing a 40-page memorandum. But I would suggest that he kind of narrated with some, he was somewhat conclusory in the way he detailed it, but he did indicate that Mr. Zotos had conducted some of this behavior. He did indicate that. But again, I could quabble with the way he characterized Mr. Zotos' behavior all day long. I quite frankly disagreed with the finding, and Mr. Zotos testified, but I can't quabble with Judge Healy, and I'm suggesting to the court that there's nothing in his decision that would suggest that you should be reversing him. He was there. This is a very intense case factually, and he made findings that I would suggest are really unassailable.
Would you say that it's a reasonable inference that the reason the surveyor went and got a policeman was because he was in fear?
Absolutely not.
Why did he get a policeman?
Again, you have to understand.
If he wasn't, as to
Your
use
Honor,
his words, concerned for me, isn't that what you said?
No, again, he said he was concerned. Now, he had his best shot at trying to testify as to whatever he was feeling. Concerned is very, very different from an apprehension of physical confrontation. I mean, we're all concerned.
Why get a policeman then?
Again, you have to put it in context. Everybody in this case started to hate each other the first week that that the complaint came out. And quite frankly, both sides were using, I think, what they call in the Chapter 93A litigation, they were using rascality to do what they had to do to defend and prosecute their particular cases. And you cannot isolate.
Could I ask you this,
Yes.
Mr. Kelly? In response, Justice Cowan asked you the question. As I read Justice Healy's findings on the civil rights claim, he focuses exclusively on the letters of complaint and says, that's what he focuses on, and that's what his findings, to the extent of findings on. And then I look at the summary of the evidence, which is contained on page 39 and following of the plaintiff's brief, which talks about an employee who was confronted, the surveyor incident, the fact that the plaintiff's children were stalked, the holding up of the rake and running at him, and various other things. I didn't see those in Judge Healy's findings. And so I just wonder what your response is as to which is really the second point, as I understood Mr. Cockfield saying that that there are subsidiary findings or lack of findings that do support.
Well, he clearly said there was no evidence of threats.
Well, Judge Healy did later in his order, it's pages A15 to 16 in the plaintiff's brief, under the discussion on trespasses and contempt, he made some specific findings about the surveyor. But he just attaches those findings to the trespass and contempt rather than to the civil rights. But there's no reason that we can't use the findings for the purposes of the civil rights count. But he never says anything about the rake in there that I can see.
And that's, again, a fact that he had to really work hard to make all the findings. Again, I want to say, Tom Zotos testified, and you haven't mentioned anything about that. And he denied almost all of this behavior. And he had a completely different context as to how all this went down. And if you're going to isolate the facts that you have been in this 15 minutes, I would urge you to go back and look at his testimony.
Well, the testimony, we would look at it to see if the findings of the judge are not supported, but the judge made findings contradictory to Mr. Zotos if Mr. Zotos denied most of this behavior, because the judge says Zotos verbally harassed and abused Mr. Clark. Clark is the surveyor. Zotos remained on his own property, but the verbal harassment did not amount to a trespass or contempt. It was, however, an intentional and wrongful interference with the plaintiff's discovery and trial preparation, et cetera, et cetera. So he made findings that I presume are contrary to your client's testimony.
And by the way, there's remedies for that, and they used those remedies, and they sought them, and they were awarded those remedies for violating the discovery rules. And so, I'm suggesting big distinction between some of the activities involved in an embroiled lawsuit and ones that are extraneous to that, which is really where the case law has gone. And I want to point out that in the original complaint, none of this was in the original complaint. So it all did arise subsequent to the original complaint. The original complaint was they took steps to curtail us from building 2 buildable lots. I would suggest there was absolutely no right to build those 2 buildable lots. And you can get the testimony of the building inspector, Wiley, who said that he made a non-conforming lot more non-conforming by his presentation of a new A&R plan. I didn't buy it, and I also didn't buy the fact that the so-called garage was a bunkhouse. So there was no way I was ever going to grant a permit for this gentleman to build 2 buildable lots.
Can I ask a fact question here, because I didn't quite understand it, maybe because it's got nothing to do with the parties here, but what did your client pay for this piece of property?
The entire house was $180,000 in 1996, when I would say that would be market price. The triangular piece of property was included in the sale by Mr. French, and I think it's important to underscore that there was an underlying agreement that no one disputes where Mr. Haufler was obliged to reconvey that property back over to Mr. French.
So that was included as part of the
and
the consideration paid to Mr. French.
Any dispute in that there was an underlying contract.
Well, that's why it's not referenced in here.
It was what we call a tripart agreement. Mr. Campanelli, Mr. French, and Mr. Haufler had executed it, and there was an ironclad obligation on Mr. Hoffler's part to reconvey the property back over to the Zotoses. It's clear on its face what his intent was, to use the cottage to try to get a building permit, which, by the way, they were successful in doing. Where the rubber meets the road is that Mr. Haufler tried to go one step further. He tried to get a new A&R plan approved by subdividing it one more time and getting one additional buildable lot. Not only did it not fly with the Zotoses, whether you agree with them or not, it didn't fly with the attorney for the town, it didn't fly with Mr. Wiley, and that's how this controversy really escalated into a place that you're now commenting on people holding up rakes. But again, I hate to reiterate, but I'm going to one more time. You have to look at all the facts, and you have to understand that this complaint morphed into a civil rights violation involving really what is a contentious pretrial and discovery-oriented part of the lawsuit. And again, Mr. Cockfield did an excellent job. He was very aggressive, and we were on our heels, and the Zotoses might have done a few things that were untoward, but you have to say this was that with an intent to deprive Mr. Haufler of his enjoyment of his property, or was it more compartmentalized into trying to protect their own property? And I'm suggesting to you, it's a very important distinction. They were trying to say,
Mr. Kelly,
I have
thank you.
also
Your ti-
the right to protect my property, and that's essentially what they were trying to do. And I thank you for your time, and I apologize that I didn't get to the other issue. I guess I just have to live with the brief on that. Thank you.
Thank you, Mr. Kelly.